Do you know if your business is compliant with federal, state, city, and OSHA laws? If you're not, there can be quite a bit of risk you probably don't want weighing on you. Thank you for joining me for this episode of HR Made Easy for Busy Employers. My name is Karen Mathews Radau with Small Business HR Services. We make HR easy for busy employers. Today, our topic is HR compliance. This is a very broad topic, so I'm going to break it down for you and touch on those areas that you have the biggest risk. I'll talk about those laws that many employers either don't know about or don't think about. There are quite a few details, so let's get started. To begin with, what is meant by compliance? The definition in our case is compliance to the labor laws, whether it pertains to federal, state, your own city, or OSHA. In order for an employer to be compliant, they must meet the minimum requirement of the labor regulations. Our first labor law requirement falls under PAGA. Since the government cannot possibly hire enough auditors to check every employer's compliance, they rely on employees to help. There is a law in place called PAGA, which means the Private Attorney General Act. That is intended to surface violations of the Department of Labor wage and hour regulations. What the law does is empower employees and former employees. The employee can be awarded 25% of the fines the government wins in these kinds of lawsuits. These lawsuits can easily turn into a class action suit, which means all employees can be involved. The most common PAGA lawsuit is when employers have missing or incomplete basic employment infrastructure. That would mean that someone is not paying attention to payroll details. One violation is not having the correct employer information on pay statements. Another violation is when hourly employees take their meal breaks after the 5th hour of the start of their shift, and/or employees are not given the required rest breaks. Also, not paying employees overtime premium pay as required is a separate violation of the wage and hour laws. Since PAGA lawsuits are usually in the high six figures or more of award, you'll want to make sure that you avoid these problems by being vigilant with payroll oversight. If you have at least 10 hourly employees, I highly recommend that you have a payroll meal break audit done periodically. This way, if there is a problem, you can discover it instead of having a lawsuit or auditor find it. Another example of labor laws that can cause considerable exposure to expensive repercussions is OSHA. OSHA and Cal OSHA laws are all about workplace safety. OSHA is at the federal level, and Cal OSHA applies to employers and employees in California. The purpose of OSHA regulations is that every employer must provide a healthy, safe, and secure environment. Secure meaning prevention of workplace violence. Employers are also required to have a written safety plan called an Illness and Injury Prevention Program, IIPP for short. That is specific to the employer and their workplace, which includes remote working. Employers must also provide safety training on a periodic basis, depending on the level of safety risk in the workplace. These requirements are for any size employer. The last category we're discussing today is having to do with leaves of absence. All leaves are unpaid by the employer except for paid sick leave and the California voting rights leave. This category can be tricky since in California there are 16 different leaves. I'll talk about 2 leaves which must be tracked since the leaves overlap with one another. Specifically, when an employer has 50 or more employees, they are required to grant FMLA leave, which means the Family Medical Leave Act. FMLA is to care for family members and can run concurrently with CFRA leave. CFRA means California Family Rights Act and is California specific. CFRA applies to employers with 5 or more employees and guarantees job protection while the employee is on that leave. CFRA provides for 12 weeks of leave per year for employees that have been with the employer for at least 12 months to care for a relative or a designated person. A designated person may be unrelated to the employee. CFRA, and another example, can be used for pregnancy, disability, and baby bonding. This leave is also unpaid by the employer. Personal leave is not required by any statute, but many employers will allow it under certain conditions. It is also an unpaid leave. I know it's a lot to remember. That's why we here at Small Business HR Services do what we do. We are focused on making HR easy for busy employers. If you'd like more information or help with finding out if your business is compliant, go to smallbizhrservices.com to schedule a free 60-minute consultation with me. You can get your free reference guide for the topics I've talked about today by clicking the link below. Thank you for joining me in another edition of HR Made Easy for Busy Employers. See you next time.